Welcome back to the next segment on the Property Practitioners Act.
What exactly is the Fidelity Fund Certificate there for? And if a Fidelity Fund Certificate has often been misunderstood, where I've had some estate agents thinking that a Fidelity Fund Certificate offers them some kind of an insurance, an indemnity insurance, if they should make a mistake because of negligence, for example, which is not the case at all. A Fidelity Fund Certificate is there for one reason and one reason only, and that is to be able to compensate a client whose money has been stolen by a property practitioner. So in other words, money goes into the trust account and it disappears. The one major change that I've noticed here is that, as I understand the present law, if you are a seller or a landlord who has this unpleasant experience where a property practitioner has stolen your money or run away with your funds, before you can reclaim it from the Fidelity Fund, the actual fund which is there specifically for this purpose, you have to first try and recover it from that particular estate agent, which means you have to sue them, you have to possibly even try and sequestrate them or liquidate the company. You've got to first spend an enormous amount of money, go to an enormous amount of risk and time before you can actually go to the Fidelity Fund itself to reclaim your funds. So the one big change I've seen here now is that they've done away with that completely. All that you have to now do, if you want to be able to claim back your money, is firstly you have to prove that the property practitioner did have a Fidelity Fund Certificate in his or her possession, number one, and number two, you have to go and lay a criminal charge against this agent or agency. Once you've done those two things, then the road is clear for you to go and claim back your money from the Fidelity Fund.
So what that's going to do is going to speed up the payment of compensation to members of the public who have been wronged by property practitioners, which is great. But what the minister now has the right to do is to cap the claims. So the minister can say, we're capping the claim at 5 million, so if you've lost 10 million, you'll be paid out, but you'll be paid only the amount of 5 million. I think that's been done to preserve liquidity and the solvency of the Fidelity Fund, because now there are going to be a whole lot more claims that are going to be lodged in a much shorter period of time. So there's going to be a much greater amount being claimed from the Fidelity Fund. The Fidelity Fund is now also going to be able to be used to fund a whole lot of other things as well, including transformation in the industry, which is a good thing. But its resources are limited. And I think the capping of claims is not a great thing to happen.
Something else that I've seen in the Act where it says that the minister may also make it compulsory for agents to take out indemnity insurance. And maybe that's why they're doing this. If they're going to cap the claims, then they're going to say, all right, you can only claim up to, let's say, 5 million rand, which is why it's obligatory to take out indemnity insurance for the balance, or in case the capping isn't sufficient.
That section in the Act, where the minister is entitled to take out professional indemnity insurance on behalf of the agents on behalf of the industry, that section was in the previous Act.
The other thing that I also want to just reflect on is I'm not quite sure why the Act requires all property practitioners to have a Fidelity Fund Certificate. And the reason I say this is the following. When one looks at a traditional property acquisition arrangement, you have your selling agent, you have your listing agent, then you have your conveyancer. Some agencies like to collect deposits themselves and use the money and put that into their trust accounts, but in my experience most estate agencies want the conveyancer to hold onto the funds and manage all the finances. Now, aside from your normal estate agent or your rental agent that obviously has to have a trust account for that purpose, as I said just now or earlier on, your property practitioners are now going to consist of your mortgage bond originators, your bridging companies, homeowners associations, people and organizations which don't necessarily run trust accounts. They don't have to have trust accounts because nothing gets paid to them. Everything goes through the attorney. Which begs the question, why must a mortgage bond originator, for example, somebody who's helping another person simply acquire a loan, that mortgage bond originator does not need a trust account. If you don't need a trust account, there's no risk of money being stolen. Why then do you need an FFC? I don't quite understand. There again, I ask myself, is this a case of just wanting to try and collect more funds to bolster this Fidelity Fund that we have? I just don't understand the need for a mortgage bond originator or a bridging company to have an FFC if there's no chance of them stealing any trust funds.
The Act does place restrictions on who can qualify to be issued with a Fidelity Fund Certificate. It limits the number of people who can become property practitioners to people who are not insolvent, who have not been convicted of crimes relating to dishonesty, people who haven't been guilty of any discrimination
Right, and then just two more smaller aspects I wanted to mention here that I've picked up also is that it's now obligatory that you have to display your Fidelity Fund certificate at every place where you commence business. So if you have a number of branch offices, for example, all of your Fidelity Fund certificates that you have will have to be displayed so that any consumer that walks in will be able to see that this organization is fully compliant. And the other thing which I've picked up now is that in any agreement which a property practitioner assists in, whether it's a lease agreement or a sale agreement, whatever the case might be, a property practitioner has to warrant that they are in possession of all the necessary Fidelity Fund certificates.
And the wording for that clause will be published in the regulations, and then it will have to just add it into all of the contracts.
Here it gets interesting. It says, if anyone has been found in any civil or criminal proceedings by a court of law, whether in the Republic or elsewhere, to have acted fraudulently, dishonestly, unprofessionally, dishonorably, or in breach of a fiduciary duty, then it gets interesting, or in any other offense for which such person has been sentenced to imprisonment without the option of a fine. So what this says to me is if you have been dragged to court whether in a criminal matter or in a civil matter, and a court finds that you acted dishonestly, unprofessionally, dishonorably, or in breach of a fiduciary duty, or fraudulently, let's stop there. It means you can never ever trade as a property practitioner for the rest of your life. The unprofessional part can be for anything basically. If you've made some kind of a mistake in your youth, you're permanently barred from ever being able to trade as a property practitioner.
It's a little bit harsh.
That's a bit harsh. And I think that if anybody ever wants to take them to the Constitutional Court, I think there's a pretty good chance that they might be able to convince the court that this is a rather harsh sanction for something that might have happened 15 or 20 years ago. And then the second part, which says, or for any other offence for which such person has been sentenced to imprisonment without the option of a fine. Now what this means is, let's say for example now you've been charged criminally. A court normally has a discretion either to sentence you to prison or to impose a fine. What this section says is if the court had in that particular instance decided whatever you've done is so serious we're not even going to issue a fine, we're going to send you straight to prison. Regardless of the nature of the offence, you can never ever trade as a property practitioner again. And I say never because unlike the previous section where they have a 5-year limitation, we don't find such a limitation in this section. And I interpret that to mean that's it. You are disqualified. You can never be a mortgage bond originator, you can never be a bridging financier, you can never be a rental agent. I think that's completely ridiculous. Again, they should cap it and maybe also say if it's linked to dishonesty or fraud or theft, that I can understand. That would make a lot more sense to me.